All right, we have some breaking news for you guys regarding our Second Amendment rights in the leftist blue bastion of Illinois. Now, Illinois Supreme Court just came down and ruled that assault weapons and magazine bans were perfectly constitutional with the state constitution. I'm about to break this down. I'm going to show you which party these guys are aligned to and how this is walking directly towards the SCOTUS, where the final showdown will make this determination. Everything will be linked in the description box below. And like I said, this is about an hour and a half old, so send this one out and spread it for our rights. Now, let's get into this. Of course, make sure you like the video, subscribe to the channel, and turn the notification bell on. But let's get into this. Illinois Supreme Court upholds state's semi-automatic weapons ban on Friday. The opinion was handed down in a lawsuit by a central Illinois lawmaker who argued that banning the sale of high-powered rifles and high-capacity magazines violates the state constitution. As you can see from the timestamp, this happened about an hour ago. The important thing here, this is the state constitution. This is the state Supreme Court. The big parallel here that I can bring to you from recent memory is when, remember Oregon with Measure 114? The federal court said, no, it's perfectly fine with the Judge Immergut who did some mental gymnastics. But the state court, that's where they held it up. That's why it's not being applied, because the state level challenges were going against Measure 114. Exact inverse here. In Illinois, the SCOTUS for them says it's perfectly fine. And now, coincidentally, they're 5-2 Democrat in that court, but I'm sure that has nothing to do with it. Let's continue, because like I said, yeah. So if you're not familiar with what's going on in Illinois and why this is so important for us nationally, here's why. The law bans the sale, delivery, import, and purchase of guns that the law defines as assault weapons. It also makes devices known as switches, which modify guns to allow them to fire more rapidly, illegal because they turn firearms into fully automatic weapons. A case in point of the stupidity of this law, that's already federal law. There's no reason to have that. That's in the NFA. You can't do that. That's a baddie. So that's kind of what we're dealing with. But let me get in here and show you what the history on this was, because it's important, because it was ruled unconstitutional by a different judge in the state. Macon County Judge Rodney Forbes ruled in favor of Calkins' lawsuit on March 3rd, writing in a brief decision that the ban violated the equal protection and special legislation clauses of the Illinois Constitution. The entire problem was that the police officers and a few different special classes of people could have these assault weapons, but the population, the civilians, couldn't. It treated people differently based off of your occupation. That's a bit of an issue, but not according to the SCOTUS of Illinois. It's perfectly fine. Let me keep going here, and then I'll kind of tie this all together, why this is so massive. Pritzker and Attorney General Kwame Raoul, both Democrats, who saw that coming, immediately appealed the judge's decision to the state justices. Democrats have a 5-2 majority on the state Supreme Court. Color me shocked. But battles over the constitutionality of the law are also pending in federal court, and this is where it all ties together. They may get their win in the state court because they have complete dominance across all legislature, all judges, and everything, even the executive in Illinois. Where this goes to a federal level is when it starts to get a bit of a problem for the gun controllers. Because when you start to look at this on a federal level and apply this across the entire nation, you have a much larger problem with what the Democrats are pushing from assault weapon bans and magazine bans, because it does not equally represent everyone in the United States. That's why they use these cities and states as these little blue bastion breeding grounds for infringement zones, but it does not apply nationally. And when they try to do it, which they've tried to do so many different states on a state level, it gets too much attention, and this exact same thing will eventually be grabbed by the nation's Supreme Court. Now, I don't know how that will turn out, but for right now, the breaking news is the Illinois Supreme Court says, no, it's perfectly fine, which only gives more fuel to the idea that it could be litigated further later on at a national level, which would defeat the entire house of cards, and the entire Humpty Dumpty of AR bans and assault weapons would come a-tumbling down. Let me know what you guys think in the comments below, and I will see you on the next one. I'm Braden. See you later.